Hi, Kate Floss here with another great video. We're talking about, as you all know, that Kate Floss has entered the heavenly realm to fight for our countries. And I've got a video today. I want to call out today Scotland, Ireland. I've got to put up my sign here. I want to call out today, help us please to the Majesty under the 1688 Bill of Rights. SOS, SOS, England, Scotland, Northern Ireland and Ireland, Australia and New Zealand. Our countries are being taken over by America and certain other entities that are determined to take over all our resources and everything that belongs to us and all of our governance, all of our lands. And they're using certain entities, I don't want to get the thing blocked out, but certain entities to achieve their goals. Now, I did enter the court. Now, we know that I entered the court, and the second prayer, do pray a declaration to the effect, clearly stating the applicant's ancient 1688 subjects' rights under Almighty God exists. So that was one of the prayers that I put into the out there. Now, I'll just go back to England. Currently in England, their Prime Minister is Rishi Sunak, a Pakistani Muslim. And then the PM of Scotland is also a Muslim, and his sidekick, or his MP sidekick, is also a Muslim, and they all come, well, one of them hides it, and two of them come from the same areas. And our Governor General, our Solicitor General is also she's from India on the Jewish side of things. And then over in Australia, they've got another Prime Minister who comes from Hungary or one of those places, who is not of the Protestant laws. So I thought that it was interesting that Boris Johnson steps down, and then the other lady goes up and takes power, unelected, not elected. Then she's in power for like 2 weeks and gets passed the baton from Her Majesty Queen Elizabeth. Majesty Queen Elizabeth passes, and then suddenly that woman just steps down and says, nah, you know what, I'm not doing this. And Rishi Sunak, who was never voted in, steps into power. And then almost the same thing happened over in Scotland. And Nicola Sturgis went into the parliament, and then she suddenly steps down, and an Indonesian Punjab, also Muslim, all three of them Muslims, took over the power of Scotland. Now, over in New Zealand, I'm just looking to see, their term's not over, but it wouldn't surprise me at all. So Jacinda Ardern stepped down. Chris Hipkins has gone into the place of Jacinda Ardern. And isn't it going to be interesting to see if he steps down and they put a foreigner, possibly a Pacific Islander, as Prime Minister of our country of New Zealand? Because it looks to me, so Australia has got a foreigner as their Premier, Scotland's got a foreigner, England's got a foreigner, and I'm thinking that New Zealand might be next. Now, I'm good. So in regards to Rishi Sunak and to the Scottish Prime Minister, wait for a moment, because I'm going to go over and tell you how all this began, where we've got foreigners in our parliament and where we've got our prime ministers and our MPs swearing themselves into parliament on the Quran, which is repugnant to the Protestant laws. It means that basically the laws of our country don't exist. So as you all know, I entered the court and I put my prayers using the 1688 Bill of Rights, and I used the Will and Mary on the Imperial. And one of the prayers that I had, I do pray a declaration to effect, clearly stating that the applicant's ancient 1688 subject right under Almighty God exists, right? So that prayer has been answered. We got thrown out of the court, but since then they've made a law that has exactly answered that prayer, which I'll show you in a minute. Now, the next one was the fourth prayer asked them to differentiate between the 1688 Subjects Bill of Rights, which comes from the imperial law of the Will and Mary. The proper one is the Will and Mary. And then to differentiate between the 1990 New Zealand Bill of Rights, which is actually an immigrant United Nations ethnic people rights, because they weren't able to stand under Protestant laws. So the 1688 is supposed to overpower that, and they had not been doing it. So I had gone into the court and asked that that prayer would be answered. So you can see here, you can actually see here that Section 11, now this was just recently passed in New Zealand. What it basically says is that the Governor-General and any ministers and any New Zealand Maori entities, whether they are an entity or another body or incorporated or unincorporated, comprising or representing any collective group whose members are one or more of any of those entities. Now that all comes from the United Nations, because our Anglo-New Zealand people are not in the United Nations Indigenous, because we're not considered Indigenous. We're just considered the dirt on the floor. And apparently we have no standing in the country of New Zealand. But the New Zealand Maori are considered Indigenous, so they're attached on to the so many million Indigenous people in the world. All sorts of entities have been attached to them, and they've been stripping our country of all of its wealth, giving it to all of these other entities. So these entities have now been put under the restrictions, and then it says here, the Governor-General and all ministers and any Maori entities must not grant any exemption from, now listen carefully, must not grant any exemption from or modify a requirement or restriction imposed by the Bill of Rights 1688. So everybody knows that we have achieved two of the prayers that we were wishing to achieve. Let me just move that out. So we have achieved the second prayer, which asks for our ancient laws to be recognised, and we have achieved the fourth prayer that we ask them to clearly identify the separation between the two. Now here it shows here, they cannot breach Section 11, and they absolutely cannot breach the Bill of Rights 1688. But in regards to the New Zealand Bill of Rights Act of 1990, which that is an act, and the 1688 is not an act, it's a constitution. Well, it's even higher than a constitution, actually. And so it clearly says there that as long as they have justified limits on the rights, if they can show that there is a justified reason why they can override that right, then they can do it in regards to the New Zealand Bill of Rights Act 1990, but they absolutely cannot override anything that's in the 1688 Bill of Rights. So I wanted them, in the fourth prayer, I had asked them to differentiate between the two, and they have done that. So now in my first case that got thrown out because they said that it wasn't worthy of the courts, and then they turned around and stole what it was anyway, which I thought was a little bit sneaky. Well, then if you looked at my third prayer, this is what we're going to talk about today. All the foreigners that are in our English our Scottish, our Australian, and our New Zealand Parliament, but specifically more so in England, in Scotland, and in New Zealand. And so that's what we're going to be, how this came to be. And part of my prayer was that I said, I do pray a declaration to the effect that when two subordinating laws from the 1993 Electoral Act 55B and C and 55AA conflict with each other, with both an argument for the declaration of our indubitable 1688 and an argument for the Declaration of Inconsistency fundamental right, which came out of the 1990 Bill of Rights, I had asked them which right shall be deemed to be and taken to be allowed, which declaration whatsoever shall serve their majesties for all times to come. So I had asked them that issue, all right? So we'll get that out now. Now, this 1993 Electoral Act, I will show you the law here. And here is the 1993 Electoral Act. Now, this is the, so I'll be able to take that one down, won't I? I'll just turn that off because I don't want to be using it. And I'll put this one up here for you. Right, so this is the 1993. Now, England, you're still got to watch what I'm doing. It's going to take a bit of time. This is the 1993 Electoral Act, which was created after they removed our 1852 Constitution, which they removed illegally. They brought in the 1986 illegal Constitution, they reckoned, in one day. And from that, they had put in the 1993 Electoral Act, which was created something like 7 years later. And in that, it says how vacancies are created. And in Section C, it says, so if an MP isn't sitting in Parliament, has been voted into Parliament, then a vacancy is created if he has failed some part of the electoral law. It's not a criminal act, but it's just simply if he has failed some part of the electoral law that he has to stand down, and then the next person on the list will come up and take his place because they're not allowed to be here. Now, it says here, in an actual fact, if he or she does or concurs in or adopts any act whereby he or she may become a subject or citizen of any foreign state or power, or entitled to the rights, privileges, or immunities of a subject or citizen of any foreign state or power. Now, they've gone ahead and believed that dual citizens can hold power in New Zealand, but I'm here to tell you that they actually can't. That dual citizens are not ever supposed to, and they're certainly not supposed to hold a passport to another country. I think the main point is they're not supposed to hold a passport for another country, because if they commit crimes while they're in your parliament, right, this is not anything to do with discrimination. It's about protecting the borders of your nation, protecting your nation and your national status. Now, if somebody goes into Parliament and they've got two passports, right, and they commit a crime whilst they're in Parliament, they steal millions of dollars. And what if one of their passports belongs to a country that has not? Now, I'm going to be telling you, because you're going to be knowing about this when we get over to Scotland. All right, so listen up, Scotland. So you just have to wait for your little tidbits, but listen up, Scotland. So if somebody holds a passport to a country that doesn't have any extradition order to your country, if they steal millions of dollars out of the coffers of your of your parliament, and if it's done secretly and dubiously by giving donations to a friend in another country, maybe somebody from Eritrea that belongs to a church in Eritrea, or maybe someone that comes from Iran or from Ukraine, or you could give donations to them, donate the money to them, and then when you get caught, you just fly out to your own country on your second passport that's got no extradition laws to New Zealand, and we are never ever able to hold that parliamentarian to account. Not only that, we lose our money. So it's a very, very bad thing to have a person in your parliament that's holding two passports. Now, Australia came up with you that you have to renounce one nationality. If you renounce your other nationality and you've got it and you're a New Zealand citizen, you can still come into parliament. But in an actual fact, you're supposed to be born to New Zealand. You're not supposed to hold another passport. Now it says here, if he or she does or concurs in or adopts. So if he does, concurs in, adopts any act whereby he or she may become a subject or citizen of any or entitled to the rights and privileges of a subject or a citizen of any foreign state or power. So that's been taken to mean that if he does it whilst he's in the parliament, then he has to vacate the seat. But I dispute that. I say it means that he should never have entered parliament in the first place with a dual passport. So if otherwise, then by virtue of being head of a... So it says here, first of all, it says, in B, it says, if he or she takes any oath or makes any declaration or acknowledgement of allegiance or adherence to any foreign prince or power, or he or she does or concurs in. So this doesn't talk about before he comes to parliament or whether he's in parliament. If he had an allegiance to a foreign power, he should never have entered parliament in the first place. And so what had happened here was that this man here, now I believe this was all a huge setup. Now this guy here was a man called, now I'm going to try my best, he was called Harry Duyenhoven. Harry Duyenhoven. And then he was born, he was the mayor of the city of New Plymouth, and he was the member of parliament from 1987. Now, I really want you to look at what occurred in 1987. Now, in 1987, over in 1987, over in England, so I'm just going to show you the years here. So in 1987, Chaudhry Mohammad Sawar, he is the Pakistani, he was a former British politician. So, and then he jumped out of Britain and he jumped over into Scotland and he became a prime minister, a member of the Senate or something. Oh, he was also in the Senate of Pakistan. See, this guy here, this is why I'm not saying anybody's doing anything wrong, but I'm saying there's something very fishy going on here in our parliaments, because he was in the Pakistan Muslim League, he was in the Senate of Pakistan, and he was a member of parliament in the United Kingdom. And I'll go down here a bit. So he went into Glasgow in 1987, which is exactly the same time that Harry Duyenhoven went into Parliament for the first time. So there's nothing wrong there. Nobody's committed a crime, but I'm just saying that I'm suspicious. Now, I'm going to come back to this guy in a minute. Now, this guy here, what's his name here? Let's see, what's his name here? So his name is Chowdhury Mohammed. He was the first Muslim MP, and he was the first MP to swear the oath of allegiance on the Quran using the method laid out by the Oaths Act in 1978. So they changed the Oaths Act. And how did they change the Oath Acts? They changed the Oath Acts to be that they swore allegiance to the king, but they didn't swear allegiance under Almighty God on the King James Bible, which would have bound them to the 1688 Will and Mary, which would have forbidden them to enter Parliament to govern over our Protestant Commonwealth nations. So this is a really, really big thing here. So they are actually changing laws so that they can infiltrate our governments, infiltrate our parliaments, and then continue to change more laws. So we're going to come back to Chowdhury Mohammed in a minute. So we'll come back to him in a minute. Now, I really want you to realize that none of these people have committed any crimes. Everything they did was legal. But why was it legal? Because they changed all the laws so that they could make it legal. But the person that was involved with most of this was Harry Duyenhoven. So he entered Parliament, and then what had happened here is that the Dutch, so I want you to look now at these dates here. So this is the Dutch. What had happened with the Dutch is that, so we'll read about Harry. He was the member. We have to go. He was born, he eventually, where's his family? Hang on. So he was in the Taranaki district. Now, we're going to tell you something about those Taranaki tribes. Now, it's the Taranaki tribes. It's just all making sense to me now. It's the Taranaki tribes that went down to the Chatham Islands and slaughtered the original peoples of New Zealand, the Moriori tribe. And so he was a member in the Taranaki's district, and we think that a lot of this stuff is all coming out of Taranaki. Now, you look at his nationality, and he doesn't have citizenship. He is a full national of the Netherlands, and he's a full national of New Zealand. I'm going to come back later and explain that to you at another time. Here we go. So, in 2003, he just happened to raise in the Parliament his status that he might have breached the electoral law. And it's because the Speaker was responsible for determining whether a vacancy existed. The matter arose after Duyenhoven applied to resume his citizenship of the Netherlands. His father was born from the Netherlands, and Duyenhoven had possessed citizenship from birth, but had temporarily lost it due to the change in the Dutch law. Now let's go and look over here when that Dutch law first changed. The Dutch law originally changed in 1985. And when did he enter Parliament? In 1987. Now, he was not part of Parliament for his entire life. He was born in 1955, and his entire life, right up until 1987, he had never been in Parliament or perhaps even interested in Parliament, and suddenly he turns up in Parliament in 1987 at the same time that the Muslim turned up in Parliament over in Scotland, and then went over to England, and also in the Senate of Pakistan. So the Dutch nationals lost their nationality in cases where they were born outside the Kingdom of the Netherlands, and they lived for an uninterrupted period of 10 years outside of the kingdom after reaching the age of majority, and did not submit notification that they wished to retain their nationality. So that just meant if they submitted notification that they wanted to retain their nationality, right, they still could keep it. But then in 1985 to 2003, it started to change again. Under the legislation, Dutch people born outside who also held the nationality of the country of their birth, they lost their Dutch citizenship if they lived in the country of their birth for 10 years and were still citizens or nationals of their birth. Now, this was the case for Harry. Harry was born by two full Dutch nationals, not citizens, Dutch nationals. And then when he was born in New Zealand, because he was born to New Zealand, he became a citizen of New Zealand. But here it's got him as a national, but I think he would have become a citizen. And so those who were issued the Dutch passport before 1990 are deemed never to have lost their citizenship. So as long as he got his passport before 1990, he didn't lose his citizenship. So they reckoned, I'll show you in a minute where he was claiming that he had lost his citizenship twice, because he lost it in the first round and then he lost it in the second round. But in fact, he didn't lose it, because there's a clause that if they were not already issued a Dutch passport previous to 1990. So if he had ever held a Dutch passport previous to 1990, then he did not lose his Dutch nationality. But in 2003, following a new amendment of the 1985 Act, the Dutch nationals with dual nationality would lose their citizenship if they held foreign citizenship and resided outside the kingdom for 10 years. In the case of Dutch nationals who possessed dual nationality pre-April, who were then resident outside the kingdom, the 10 years would begin from April 2003. So that would mean, it's a bit complicated, but that would mean that if he reapplied, if he held his Dutch passport and his dual nationality pre-2003, when he was sitting in New Zealand Parliament, as long as he had not, his 10 years of not residing in the Kingdom of Netherlands of 10 years would have started on April 2003. Now, he reckons that he went to apply for the passport immediately, because he reckons that he did not know about the previous laws, and so he had quickly so he reckons that whilst he was in Parliament, he had quickly gone to apply for Dutch nationality so that he did not lose, that his 10 years would start from then. That's what he is reckoning. That's what I'll believe you, thousands wouldn't. The amendment that lets Dutch nationals who hold foreign citizenship and reside abroad keep their citizenship by either having a principal residence in the Netherlands for at least 1 year after applying for a Dutch passport or proof of Dutch nationality before April 2013, the end of the 10 years from 2003. A new period of 10 years starts on the day that the person is issued with a passport or proof of Dutch nationality. So so they keep changing the laws for him. So they really were specifically changing the laws for him so that he could be in New Zealand Parliament. It looks like a bit of skullduggery going on here. So they then allowed him to continue to be in New Zealand Parliament it would have started from 2013. However, I think that he left and it was not necessary for him to stay. So presently, now, from April, the person voluntarily acquired it before April, so anybody born later than that, immediately, if they applied for another passport, they lost immediately their Dutch citizenship. Immediately upon their naturalisation in another country, they immediately lose their Dutch passport. And then, so this was a new law for them. And certainly over in the Netherlands, Dutch people are certainly not, foreign people are certainly not allowed to be in their parliament in any way, shape or form. You have to be born to the Netherlands or you can be born in Europe. Now, ours used to be you had to be born in New Zealand or you could be born in the UK, which was England, Scotland and Northern Ireland. And at one point it was also if you were born in Australia, because we all had the same laws, right? So then what came out of that? So then there was a select committee hearing when he was in the parliament, and there was this argument that went on. Now, I'm going to post up the links to these. So I'll post up the links to these. So I better keep it up there so I know what links I have to post. But I'll post up the links to these after I finish with that. Okay, I'll just take that one down and put that one up. And I'll just close this down so I know what's going on here. So this, I'm going to get to your Scotland and Ireland in a minute, but I've just got to do this. I know it's a long video, but you can watch half and then watch the other half or turn up the speed. So then Leanne, I think it was, now I've been reading all of this. So hold on, I've just lost a little bit of where I was doing. Here's Winston Peters, and he had something to say about it. Now, but before Winston Peters, there was an argument that went on between Leanne Diesel and Winston Peters, all right? And what Leanne Dalziel, now Leanne Dalziel comes up a lot in my videos. If you look at my earlier videos, she's I'm not good. There's a whole video on her. So she's come up here again. She seems to be involved a lot with putting many foreigners into our parliament. But she said, I preferred an interpretation of 55(1)(c) that did not produce an absurd result. So she basically said, I don't like the law. She said it's an absurd law that you can't be, but she's interpreted it wrongly, and I'll show you why. So the key point here, the operation of Section 55 chosen by some people in respect of the interpretation produced an absurd result. The absurdity is that someone who can stand for Parliament 3 times with Dutch nationality and twice without even knowing that he had had it and had lost it, was somehow offended the democratic traditions of this parliament. This parliament states that people can stand for parliament if they have dual nationality, and I'm just disputing that. They're supposed to renounce one, all right? And I will tell you why. I'll just bring it over now to show you why, exactly why that is disputed. Because we have got, oh, now I've lost my, here it is. Now that comes under our New Zealand Bill of Rights, or the Will and Mary over in England. Now this is the supreme law, and if you remember here, as we can confirm in the Weather Act, which is in here, that they cannot grant an exemption from or modify a requirement or a restriction imposed by the Bill of Rights 1688. And under the Bill of Rights 1688, it says, and I do declare that no foreign prince, no foreign person, prelate, state, or potentate has or ought to have any jurisdiction, any power, any superiority, any preeminence, any authority, ecclesiastical or spiritual, within this realm, so help me God. So that says that foreigners are not allowed to govern over us. It's as simple as that, Leanne. It really is as simple as that. Even without any other subordinate orders, it's forbidden for foreigners to be in Parliament. Now, the best that you could interpret that to be is that if they were a dual national, that they would have to completely and absolutely renounce it and only have the one nationality, that they would be forbidden to hold a dual national, another passport, because of the reasons that I explained to you. They can run away with all our country's money. It's like giving the bank manager a ticket to the moon and giving him all your money and saying he can fly to the moon with all your money that you're not allowed to extradite him back from. It's just, that's absurd. And so she said that he had already been in Parliament when he had his Dutch nationality. And then he had lost his Dutch nationality twice, apparently. And he reckons that he didn't know it. I'll believe you, but thousands wouldn't. It's a case of that, isn't it? Yeah, it is definitely a case of that. Now, then she goes on to say that by passing that law, the suspended operations, that is absolute nonsense. We've given ourselves some time to do some real work on the legislation, which they decided to change the law so that we can make it mean what it should mean and what we intend it to mean. I do not believe that any Parliament intended for Harry Duyenhoven to lose his seat in this House because he sought his Dutch nationality. Harry Duyenhoven was born with dual nationality. He was born New Zealander and he was born Dutch. That is not true. That is his status today. Nothing has changed. The Dutch laws changed. But this is, there's a bit of a story there, but I won't go down it. But in an actual fact, what he's saying is that we don't like this law because he's a good man. And so since he's a good man, we should break the law for him, which is not what they say to us when we're driving down the road and we didn't put our blinker on. It's not what they say to us when the stoplight is on orange and we continue through, and then they stop us at the other side because it went red as we were going through, and they give us a fine. They say to us, the law is the law is the law. We know you're a good person. Just like the man that was sleeping in his car and the policeman ordered him for an address. He said, I don't have an address because I'm sleeping in my car. So the policeman arrested him and put him into the prison because he didn't have an address. Is that right? And they said to him, well, that's the law, and so you have to do that law. And so they've basically said, since Harry is such a nice person, that we can change the law for you, Harry, but not for the rest of the population. So this is for someone else, and this is not for me. This is for you, and then this one is for me. Yeah. So Harry gave evidence, and he said that he had never applied for a Dutch passport. I've read media reports stating that he has applied for a Dutch passport. He never has. He's a proud, well, Kiwi they call him because he's not really a New Zealander with a Dutch tradition. And I say, well, I don't know, because when I looked at all of those laws, it said that in order to be privy to the 10-year law, they had to show that they had Dutch nationality and Dutch passport previous to them passing the law in 1985 and in 2003 and all of that. And so I'm not sure that it's perhaps that he didn't apply for Dutch passport, but he certainly held Dutch nationality through his parents, and he certainly held full Dutch nationality through his parents. And then later on they said you had to apply for a passport to prove that you had Dutch nationality, and it may be at that time, but certainly he didn't hold a Dutch tradition. He always inherently held Dutch nationality through his parents, and that should have excluded him from Parliament anyway. That is a fact, because later they changed the New Zealand law and said at least one parent had to be a New Zealander. So then he said, so finally, I don't think I need anything. Oh, then they went on to say, well, here's another foreigner in our Parliament. They turned around and threw it at Richard Worth. Richard Worth, this is a man who has agreed to represent Monaco's interests in New Zealand as an honorary consul. So they gave a person from Monaco, and I'm starting to get suspicious of all these countries. How come a person from Monaco, under the Monaco royal family and Monaco nationality, held an honorary consul within New Zealand and was negotiating New Zealand contracts over in Monaco? Now, there's a lot of stuff going on here, because if he was still here, well, there's a whole nother story there. So they were saying, if he can do it, then how come our Harry can't do it? You see, this is the slippery slope that you go down with. When nobody committed any criminal act, nobody broke any law. Well, they did. They broke a law that was not a criminal law. And the consequence of breaking that law is that you need to vacate the Parliament. You don't go to prison, you don't get a fine, but you step down and vacate the Parliament. So yes, you did break a parliamentary law, which is not in a criminal law. So, and then they said, well, if he can do it, how come our Harry can't do it? Because at least our Harry was born in New Zealand, and the man from Monaco wasn't even born in New Zealand, and yet he's working as a consul in our country negotiating foreign contracts on behalf of New Zealand. I mean, you just can't make this stuff up. And then finally, one of the absurdities. Now, here's what she said. She's saying if I entered Parliament with a dual citizenship, I could repudiate the New Zealand citizenship after an election and not vacate my seat. Now, this is where I oppose her. She's turned around and said, if I have two passports, I entered into Parliament, one of those passports I hid in my bag, and I entered on my New Zealand passport, and then while I was in the Parliament, I manipulated my position and I manipulated the law, and I renounced my... This is exactly what I'm saying to you. If I renounce my New Zealand citizenship, I could remain in New Zealand Parliament with my foreign passport. And not only that, if I was a very high up minister and I was in control of millions and millions of COVID-19 health response monies that nobody knew where it was being spent, and I renounced my New Zealand citizenship, and if it got found out that I had stolen that money or used that money for nefarious purposes, I could then I've already lost my New Zealand citizenship, I renounced it completely, I got my passport that I've always held while I was in Parliament, and I flew off to the moon where there was no extradition to bring me back. And that is exactly why her announcement that is the absurdity of the law is incorrect in the way that she's reading it, because it doesn't say that. What it actually... I hope I didn't turn that off. What it actually does say... I might have turned it off. Did I turn it off? No. What it actually does say is that if he or she takes an oath or makes any declaration or acknowledgement of allegiance or adherence to any foreign prince or power. So Harry had not done that, right? If he or she does or concurs in or adopts any act whereby he may become a subject or a citizen of any or entitled to any rights, and that is what he did while he was in Parliament. While he was in Parliament, he took on... So previously to that, even though he was a Dutch national, he had not made the oath to the Netherlands. And so he entered Parliament like that, right? And then while he was in the Parliament, he changed it. And then they manipulated the law and changed it to suit him whilst he was in Parliament. If you don't think that is, that is a deep, deep manipulation of ministers of Parliament, ignoring and desecrating and just absolutely having absolutely no acknowledgement of any law that is in place against them, because they've entered Parliament swearing on the Quran, on other laws, and they don't swear to the 1688 Will and Mary oath, the correct oath. And it all comes back to that Will and Mary being violated again and again and again, just violating Jesus and just stabbing him in the side. That's what they're doing. Now, so that's what she went on and said. And then, oh God, it's an hour in already, but I'll just keep going. This is probably going to be a 2-hour video, but you can watch half an hour and then come back and watch it later, or you can just go and read for yourself. All right. So she said that that's exactly what she could do. She said, I've got a Scottish granddad, and she said, my husband's dual, even though the Queen is the Queen of England, is the Queen of New Zealand, and it is to her that we swear allegiance in this house. Even if my application were declined, I would have vacated my seat under 55(1)(c) just because I applied. That is the nonsense of the current law. The law, the way it stands, is nonsense, and it must be reviewed. That's what she said. So she said, not in haste, but properly by a select committee looking at the Electoral Act. Now, I'm not going to read all of this to you, but as you go along and read it, what they actually go on to say later is that they changed the law to allow him to stay before they sent it to the Solicitor General to determine if, all right, so this happened with him. They sent it to the Solicitor General to determine, or the Attorney General, or the Assistant Solicitor General, to determine if his seat was vacant. And while it was sitting there at the Solicitor General, overnight, in 3 readings, first reading, second reading, and third reading, so in 3 days, they changed the law before the Select Committee and before the Solicitor General had ruled that he should vacate the seat, but by the time that order came down to vacate the seat, the Parliament had already changed the law to let him stay. And then that is the debate that they're having now about whether they should have done all of that or not. And then obviously they decided in this debate, everybody in this debate said that they should not have done that. And anyway, so my view is that Section 55 should not be interpreted in a narrow technical way. The general public does not buy the sophistry we have heard from the desperate and dateless leader of the opposition. She's saying that about Winston Peters, who is a lawyer, and she had been told by the Solicitor General that she should vacate the seat. She was actually on the committee, and she was there when the entire committee said he must vacate the seat, and she opposed it, and she's turned around and called Winston Peters a desperate, dateless leader of the opposition. This is why I think we need to vote Winston Peters and make him the Prime Minister of New Zealand, because he fought tooth and nail against this, and he said, you know what, Harry's a lovely person, but the law's the law. If you want the public to follow the law, we've got to follow the law. These are the laws that we have to follow, and until such time as you change the law, you've got to follow it. So they had a bit of a tangle, and Winston Peters said something, and then that was not put in here. But the answer from Bill English said the member is a lawyer. So it perhaps is that Winston said she's not a lawyer and she's got no right to be interpreting the law at this time, because obviously, even to me, she's obviously interpreting it wrongly, and I'll show you why later. Now, I'm going to have to come back with a part 2 video. So then they say she is a lawyer, but there's no evidence of that in her speech. Richard Worth is an honorary consul to facilitate. That was left out. And then she said, at least I pay my taxi fares, which is a distraction, is childish, it's a distraction. And she had no answer to him. So once again, she has belittled Winston Peters in Parliament. And then he said the member would, but she would not know what the law of specific performance is about. If someone does not get a service, he or she does not pay. Not in my book. But then again, that member was pretty rough on the law. And that is why she was a trade union lawyer. Now, a trade union lawyer is not a constitutional lawyer, and I don't even think they have to pass the bar. They're like human rights advocates. They only have to pass a few papers on the law to be a trade union lawyer. So Winston said, when she was saying all of that, she was speaking in an absolute legal capacity. And Winston said, we can't hear her on any of this because she's not a lawyer. Bill English said the member is a lawyer, and Winston has come back and said she's very rough on the law, and that is because she was a trade union lawyer. Right, so the rest of this you can go ahead and read it for yourself. But if you scroll down here, it talks about when they changed the law in the first, second, and third reading and all of that. So I'll get off of that now. Now, I want to go and show to you. So I'll just, where did I put that? So I wanted to go and show to you. So I'm going to leave that there. And then I'm going to show you the Australian law. So this was a, now I'll post this up for you as well. So this was a university evaluation from over in Australia of what they, oh, okay, just wait for a minute to get my laws in order here. Oh, that's what I was, that's the, all right, so that is done. So that goes up there. And then we've got an Australia, you just have to give me a moment because I have to work from multiple screens here. All right, so I'll just go here. So this guy here, now he turned around and says that what he was, oh, I should have read this. I'll have to go out and extend this a wee bit so I know where I am. So he was doing the law change and he talks about the Australian Constitution, which where is he talking about? All right, hang on. So this is just talking about, I'll just find the things I need first. Retrospective. In order to, where to. All right, just a moment, if you can just bear with me for a minute. Oh, lost it now. I might have to come back. To that, because it talked about in the Australian, oh, right, here, I've got it, right, okay. All right, so now that I've told you that, I don't want to mess around with that too much, right? So after that happened in Parliament, right, so you remember what she said, and she wasn't a lawyer, and she was saying that it meant that you could enter, it meant that how she read it is that if you if you entered Parliament with 2 passports and renounced your New Zealand citizenship and retained your foreign citizenship, that you could enter the Parliament, you could stay in Parliament and not vacate your seat. But if you entered the Parliament and you had only a New Zealand citizenship, and you made allegiance to another country and got another passport, that you would then have to vacate the seat. She said it was an absurdity, but it doesn't say that. What it basically says is that if you hold an allegiance to a foreign power, you should not enter Parliament in the first place, because of the reasons that she herself said, that they might renounce their New Zealand citizenship and run away on their foreign passport, and you can't bring them back. So they're not supposed to. Now, that is confirmed here. Now, when he wrote this, he was talking about, you can go and read it, he was talking about, were they correct to let Harry stay in Parliament and change the law retrospectively while he was in Parliament so that he could stay there? All right, so that was the issue that everybody's been arguing about. And you'll have to go and read that for yourself. But in here, it clearly says that in certainly part of the Constitution of Australia, Section 44, the Constitution of Australia provides for the disqualification of a person from being chosen or of sitting as a Senate or House of Representative members if they are under any acknowledgement of allegiance, obedience, or adherence to a foreign power, or is a subject or a citizen, or entitled to the rights and privileges of a subject or a citizen of a foreign power. And where does that come from? It doesn't actually. So he's gone on to say, well, New Zealand doesn't have a constitution, but we damn well do have we don't need a constitution, because we've got the Supreme Law that says no foreign prince or foreign person. And if you've got allegiance to another country, then you are a foreign person. You just simply are, as soon as you're a citizen. So prelate state ought to have any jurisdiction or power. So clearly she is wrong in what she was saying. And Winston Peters quite honestly pointed out that she was not a lawyer. Now this video is getting long, so I'm just going to quickly go to the law change that I wanted to do a bunch of others for you, but I really, the time has run out. But what I will show you is the law that they changed for him. I'll show you the differences. And this was exactly my case that I sent. I did send it to the court. Oh, I've turned it. Oh, I did turn my case off. So I did send to the court it's in the third prayer that I sent to the court. And here's what Helen Clark did, all right? So I'll just show you that. So I'll just go down one. Right, there you can see how vacancies are created, and then 55B, cannot take an oath, and 55C, if he has concurred or adopts in or whereby he may become, or it's here where it says or is entitled to the rights, privileges, or immunities or a subject of a foreign power. Here, he must vacate the seat. And over here, they've changed it. Then they've said, they put in section 55AA, which they added later, 55A, if a dual or multiple citizenship is permissible in certain circumstances. And it doesn't tell the certain circumstances. It says, despite section B and C, it doesn't. So basically they've said, I can just show you here. So basically they've said, okay, basically they've said over here, I'll make that a bit bigger. So basically they've said over here, you cannot, if you are entitled to the rights and privileges, you cannot hold a seat in Parliament, right? And then over here it says, despite section 55B and C, you can. And then it says dual and multiple citizenship is permissible. You can have, do you know, according to this law, you can walk into a New Zealand Parliament and you can hold a passport to Iran, you can hold a passport to Saudi Arabia, you could hold a passport to Iraq and Israel. You could hold a passport to all those countries. Then you could come to New Zealand, get your New Zealand citizenship after 5 years. After 10 years, you can enter New Zealand Parliament, renounce your New Zealand citizenship, and continue to hold your 3 national statuses of the foreign countries, and your seat will not become vacant according to section 55AA. That's what she's done, and this is why Winston Peters said she's not a lawyer and she should not be advising the committee on legal issues, because she wasn't a lawyer, she was a trade union lawyer. Now, I'm going to have to make a second video, so I'm not going to make it today, but I will show you the people that I'm going to be talking about in the next video as a follow-up to this one, because this has already gone like an hour and a half. So the next video that I'm going to make is we're going to be looking at this man here. Now, if you go and look at him, his name is Hamza Yousaf. Hamza Yousaf. And because of all of this thing that went on with Harry Douyi, but let's remember that England changed the oath in 1978, which permitted all of this to occur in our countries of England, Scotland, Ireland, Australia, and New Zealand. So, and I'll tell you, America and Canada, both of them raced in and protected themselves. So that's a whole nother story. But the law was changed in 1978 whereby they could swear the oath on the Quran, and they no longer swore the oath to Almighty God under the 1688 will and Mary. They now swore the oath only to the king. They said they would be allegiant to the king. Now, the king is supposed to vacate his seat if he's not upholding the laws of the 1688. So there's a whole lot of strange stuff going on. I'm not saying anybody's breaking any laws, but I'm saying this is not what our countries, this is all the wars that we fought, all the 30 years war over in Germany, all the wars that went on in Scotland and Ireland. And I will just say to you that Harry Douyi Hoven is a devout Catholic from the Roman Catholic era over in Germany, who comes out of 30 years war that were fighting against the Protestants and hanging the Protestants in the street and slaughtering and burning the Protestants alive. Now, I've got a really hot story to tell you soon. You're going to be wanting to see the next video. But this guy here, he doesn't even tell you what, and it's exactly what I've just been talking about. He doesn't even tell you what nationality he is, what citizenship he got. It just isn't there. He doesn't even tell you who his parents are. That's how little that we know about Hamza Youssef. The only thing we know about him is that he is a devout Muslim, all right? Now, I'm going to do a story on him, but we can't do it just now. Now, his sidekick over in Scotland is this man here. Now, this man here is the son of Chowdhury Mohammed Sarwar. So, Chowdhury Mohammed Sarwar is the man that came to power in 1987, around about the same time that Harry Duynhoven went to power. That is the same time that Chowdhury, and Chowdhury was in the Pakistan Senate, and he was in the English Senate, and he was in the Scotland Senate, and he swore allegiance. He was the first person. See, do you see the slippery slope that we're going down? Or not going down, we've gone down. This is the slope that we've gone down. So he's not a bad man. He's just following the laws that our kings and queens are making. That's all he's doing. So he hasn't broken any laws. But I'm just saying, how come these laws are being made? I'm scratching my head. It's not making sense. It's the absurdity of it all. It isn't making sense. So there's a story to talk about of him, all right? And it involves, it does involve these youth, these Pakistani youth. I can find it. So he's got a Pakistani political career, an English political career, a Scottish political career. Harry is over in the Netherlands, and then he's in New Zealand. He's got the dual nationality. Now, hang on, let me just find something on him. He he had been stepped down from a seat, but he was involved. Now, this is what I'm talking about, these extraditions. When you've got a foreign passport in Parliament, as a lot of them do, and then they renounce their New Zealand citizenship, they only hold the foreign passport. Well, this is the kind of people. Now, he, as a show of, I don't know if this was set up or not, miraculously, just before he stepped up, he was fighting about whether he was going to be even allowed in Parliament over some other issues. And he was pivotal in having these kids here, Danish Zahid, now remember that name, Zahid, Imran Shahid, and Zishan Shahid. Oh my God. And Mohammed Faisal Mustaq. And so you can click onto what they did to Chris Donald. Chris Donald was a 15-year-old white boy, and they kidnapped him, and listen to what they did to him. Here's what they did. It's just cruel. They kidnapped him, the kidnapping. They were associated with the Pakistani gang, and they had had a fight at a nightclub apparently with some white boys. So they decided to just choose some white boy off the street. And then he was taken on a 200-mile journey. This little boy was, I've got a 16-year-old son, you know. So this boy was 15 years old, and his only crime was that he was white, all right? And they made him travel 200 miles, and they made phone calls looking for a place to house him. They couldn't find anyone that would house them. So they took him to Clyde Walkway near the Celtic Football Club. Now, there's many meanings in these names. And there they held his arms, and they said they must have held his arms because he had no defense wounds. They stabbed him multiple times. He had injuries to 3 arteries, one of his lungs, his liver, and his kidneys. But do you know what they did? They burned him alive, and he bled to death but he didn't die from the burning alive. I don't know if he bled to death and then they burned him, or they were burning him alive and then he got bled to death but didn't die from the burns. But this was a horrific crime. And then that man there, who'd been previously kicked out of office or for some other things, he negotiated. The people that did that crime ran away to Pakistan, and this is what I'm saying to you, these are all Pakistanis, and Pakistan has got no extradition orders. And so he managed to get them extradited. Pakistan broke their law, so therefore, since they broke their law, that's why they're giving us the excuse that we need to break all our laws. You see, this is what has become of our parliaments, that are just breaking law after parliamentary law after parliamentary law after parliamentary law, and they're not being honourable to their office. And this is exactly why I served them and ordered them to come to court, because I'm saying to them, what the hell are you doing? You know, you've all got kids. Chowdhury, you've got kids. You know, Harry, you've got kids. Rishi, you've got kids. Why are you putting them in such danger when we've got these protective laws so that your kids can come from your countries to our countries and be protective, and you're all in our parliaments destroying those laws? What if it's your kids that are beaten up and burned alive? Because this burning alive, stabbing people and burning alive, this occurred during the 30 Years' War over in Germany, where the Catholics and the Jews and the Muslims were absolutely slaughtering anyone that didn't want to stand under their laws. They were slaughtering them, cutting out their tongues, burning them alive, slow, torturous deaths. And that also comes under our see, they're just constantly violating our 1688 Bill of Rights, because that's what our 1688 Bill of Rights says there. This is exactly why foreigners are forbidden. Foreign allegiances are forbidden in our parliament because of what those boys did. They could have been sitting in parliament and done that while they were in parliament, and then scuttled off to Pakistan and never been able to be extradited back to our countries to be held accountable. And that is a violation. That is exactly why in our 1688 Bill of Rights, the most important law that we ever had, I'll make it bigger for you. I want to make it really big because of that boy, that poor dear boy. And then the law that says here, it says here, excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. No cruel and unusual punishments may be inflicted, and no foreigners, persons, states, or potentates may enter our parliaments and have any authority over us. Because what if those kids, they were kids at the time, and they got like something like 5 years. They got a very small, very, very small. But what would happen in this day after Harry and after Parliament changed that law when they shouldn't have? What would happen if those 5 kids were sitting in Parliament and they just decided that they were going to make a ruling in Parliament? They were going to be sat in Parliament with their Pakistani parliamentary passports, and if they ordered a certain group from the Pakistani Muslim League to go and slaughter cruelly and to punish cruelly, because they have not sworn the oath to the 1688, they've sworn on the Quran. And by swearing on the Quran, that eliminates the 1688. What if they ordered a bunch of people to go and commit cruel and unusual punishments on all the Anglo-Saxon people, to slaughter them, and then they just got on a plane and off they went to Pakistan, and they've got full and absolute immunity? And we've got, so what if that happened when we've got Rishi Sunak, who is a Pakistani, who is the Prime Minister of the English Parliament, and is he the Prime Minister of the UK? I don't know that question. Then you've got one of the sons of, then you've got the son of Chaudhry Mohammed Sarwar as an MP in Parliament, working very, very closely together. So this is his son, Anas Sarwar. Anas Sarwar. I know that because I used to work in a Muslim school, so I know how to speak that name correctly. Luckily, because otherwise I would say it the other way, which would be very bad. But Anas, so here's the son of a Pakistani Muslim, and then we've got the First Minister of Scotland. So imagine if you had those 5 kids that already had it in their head at a young age to burn people alive and stab them, just like in the witch trials, which was why the 1688 was brought about, to stop the cruel punishments. What the people said is, they said, if you want to have a punishment of death, go ahead, we can stand that. But these cruel punishments, like they did to Jesus and the other people that were up on the cross that day, where they have to spend hours and hours and days and days and days dying, cruel deaths. What would have happened if those kids had just waited for a few years and they were in Parliament, and they did that while they were in Parliament? And what would have happened if Hamza Yusuf, who is a Muslim, was running the show, and then if you had Muhammad Chowdhury in the Parliament, and then you had his son in the Parliament over in Ireland maybe, and then you had Rishi, see, I'm still watching Ireland, then you had Rishi Sunak, who was a Pakistani. What would have happened if they had ordered the slaughter of many Anglo-Saxon Celtic people? It is interesting to me that they did it on the Celtic grounds, and we don't even know. See, if you look on here, he does not tell you what his nationality is. He does not tell you what his citizenship is, and he doesn't tell you what his nationality is. For all we know, he might not have any Scottish citizenship. Oh, yeah, I've gone ahead and done it anyway. And then this man here, whom is his father, you can look on here. Now, he does not, oh, he does. He's got full Pakistani nationality, and he had British nationality until 2013, which means that he dumped his British nationality and then he hopped on over to Scotland, I think, and entered the Scottish Parliament, because he entered the Scottish Parliament. Oh, he relinquished his UK citizenship in July of 2013, which this is all matching up to that Netherlands Dutch law that was done from a place called Zeeland, which is what New Zealand is named after. And he dumped it in 2013 when they made their final citizenship law. And then, I'm not sure when he went into the Scottish Parliament, but anyway, so he renounced his British nationality, he retained his Pakistani nationality. See, these are the people now that are running their parliaments. Now, but then this man here, who is appointed by the king, we don't even know what nationality he is at all. We just don't know. And he's in the highest position. So this occurred, by the way, with the Scotland Act, which came about in 1978, which was in conjunction, well, interestingly, when they made the Scotland Act, they also changed the Oaths Act over in England of the oath that they had to make. They were both changed in 1978. So, and then, actually, I'll just go and do it here. In 1997 to 1998, so 1997 is when Harry came he came 1987, I think, but he came 1987, but he was still there to 2003, where this whole, the change started in 1985 over in the Netherlands that went right through to 2003. Those changes were occurring. See, there's something going on here. I don't know what, but there's something going on here between these countries, and they're all making decisions about our lives, and we just better freaking wake up and start figuring out what's going on. Now, the 1997 referendum, and then Scotland became some kind of independent from the First Minister took the official oath. So they took something like 1999 or something. They had a referendum anyway, and they were for the first time permitted to have their own parliament. And since they've been permitted to have their own parliament, all this skullduggery has been going on. I do know that New Zealand is kind of, so what I'm saying to you here, so we don't know about him. So I'm just going to leave it all at that. I'm going to, right, so I'll try and post up. It takes me a long time to put up all the links. So I think what you can do, rather than me put up all the links, is you can just Google it. A lot of it you can just Google yourself. And some things I will put up the links. Oh, and so So the most important thing that I want all of you to remember is our 1688 Bill of Rights and the protections that it gives to our countries. And don't forget that Kate Floss is already in the courts, and the second prayer and the fourth prayer have already been answered. So I asked for two things in those prayers. The first prayer that I said that I would wanted them to, I actually had asked for a declaration. I've got a declaration here in this law. This is in the Weather Act. I have got the declaration. The prayer was answered in that. I had said, could you please make known to the people of New Zealand and to the Parliament and to everybody that our 1688 Bill of Rights, or they call it Bill of Rights 1688, so I'll have to get it right. Our Bill of Rights 1688, now this is not an act. It's not even a constitution. It's higher than a constitution. A constitution can be changed by a referendum, but the Bill of Rights 1688 can't even be changed by referendum. Nobody can change it. Not even a king can change it. And it's up to us to start using it. Use it or lose it. So we had the prayer answered to have it made known to everybody in Parliament that this is a part of the laws of New Zealand. It's part of our ancient laws. They must follow it. They cannot breach it. The second thing that I asked in the fourth prayer, if they could make known the difference between the Bill of Rights 1688, which cannot be breached, and the 1990 New Zealand Bill of Rights Act. One is called BOR and one is called BORA. And the BORA is a United Nations immigrants law, and also used for so-called Indigenous people who said that they didn't have any rights. They like to use it. It's for them, but it's got a justified limitations, meaning that if they want something that would be repugnant to our 1688 Supreme Law, then they can't have it because it's a breach under Almighty God. So that's been a long video. I don't know. I think it was about an hour and a half. So that's it. Kate Floss signing out, and we'll be talking about this a lot more in the future. But we're going to the heart of the problem. The 1993 electoral law is in my first case in the first court, and we have not had that prayer answered as of yet, but we hope to get it answered by a declaration, which we should get. We pray. I do pray. And I've put King Charles up on the board, and I've said the prayer to King Charles. I've said, King Charles, I do pray that we get a declaration that our 1688 continues to be the supreme Protestant law of our Commonwealth nations and England, Scotland, Ireland, and New Zealand, and anybody that wishes to remain a subject of His Majesty the King. And Queen Camilla is not a majesty, but she's Queen Camilla. So King Charles will become His Majesty King Charles. It's going to be interesting to see if they use His Majesty. And Queen Camilla will not be Her Majesty. She'll only be Queen Camilla. That's all she'll be. So I've sent the prayer, and the prayer's sitting in the Supreme Court. I'm going to be going in and doing some stuff at the Supreme Court tomorrow. I think I've got some plans in my mind. All right, signing out, Kate Floss, and I do pray.